All right, so tonight we're going to talk, at least start out this week, maybe finish next week, I don't know, we'll just see how we get to. We're going to talk about labor unions, and we really haven't spent a lot of time on labor unions in this class. We haven't really spent any time, but it is important. It's an important part of employment discrimination and labor law, if you will. So when you have a class that's entitled Labor Law and Employment Discrimination, this is the labor law part. And even though it's first in the title, I think we'll save it for last for a couple of reasons. Number one, labor unions, for the most part, won't affect all of you. And everything that we've talked about so far will affect you in some way or another, or could affect you some way or another. The laws regarding labor unions don't always affect everybody who works, so that's one reason we put it off. Labor unions also appear, at least they did appear, to be dwindling somewhat, okay? And their numbers have gone down. And before we, just kind of to kick off the discussion, labor unions, good thing, bad thing, what do you think? I have a message. Hang on just a second. We'll just make sure I don't have an emergency. Good thing or bad thing? I need milk. It's not an emergency. Well, yeah, at our house it could be an emergency. Okay, I'll make sure I get that milk. What do you think? Anybody here a member of a labor union, by the way? Okay. So, do we need? Let's do it this way. You don't want to tell me if they're good thing or bad things. Let's go this way. What are the benefits to labor unions? Labor unions have any benefits?
Higher pay, better working conditions.
Okay. Yeah, Tom's absolutely right. Without labor unions were certainly important and essential for higher pay, okay, and better working conditions. All right. Labor unions are certainly essential for higher pay, better working conditions, safer working conditions, okay? You have to keep in mind, labor unions kind of came around during the rapid industrial development that occurred right after or during the Civil War, okay? And when you had that period of time, employment and conditions included long hours, so also better working hours, and I assume Tom's probably including that in working conditions. But with no laws out there, employers could hire people, pay them very little, work them long hours, work them in unsafe working conditions, and get as much out of them as they possibly could. And people began to realize, hey, by getting into a labor union, we can have better wages, better working conditions. Now, how is it that labor unions result in better working conditions, better wages? I mean, how can that happen?
Threat of strike.
Okay, threat of strike. Jackie?
You have more power to the individual worker that the individual worker may not otherwise have.
Okay.
Because if you just have one person who won't put up with the conditions, it's like, okay, we'll fire you. But if you have a lot of them, then there's actually some clout there. Okay,
and Tom says strike. Jackie says you got more numbers and power. Both are actually right together, okay? Because the more you have, then there's force in numbers. There's strength in numbers, okay? And that's what a labor union is. It's a group of like-minded people, one way or another, that basically come together to show that they have bargaining power. And part of that bargaining power can be exercised through strikes, and as Tom mentioned, strikes. And we'll talk about strikes 2-3 weeks from now, whenever we get to that point, okay? So we will talk about strikes and the effect of strikes and when you can strike and when you can't strike. But certainly that is one of the ways that if you have strength in numbers, you can put some pressure or influence under an employer, whereas one individual by himself going to his employer and says, if you don't pay me more, let's take Kyle. Kyle comes to me, works for me. I'm a slave driver, so to speak. I'm a bad guy to work for. And Kyle says, if you don't pay me more, I'm going to quit. What's my response going to be?
See ya.
See ya. Quit. Walk out the door. And by the way, don't let it hit you on the way out, right? Okay? I don't care. Because if it's just Kyle, I can go to Patrick, I can go to Corey, I can go to Drew, I can go to anybody and replace Kyle. Okay, maybe not Kyle. I don't want to say but you get the idea. Okay, you get the idea, and that's where labor unions came around, and that's the reason. What are the disadvantages to labor unions?
They put other people out of jobs.
Okay, and Tom says they put other people out of jobs. How do they do that?
From an economic standpoint, if you pay more people or a fewer amount of people more money, there are going to be other people that won't get jobs because they have to pay the other people more money.
Okay, I may be spending, I have a limited number of resources as an employer, all right? And if I'm paying more money to this group over here, I may not have that money to spend on this group over here, so this particular person may be without a job. Why else? Or how else can labor unions be a disadvantage?
They have very strict rules. You have to abide by their hours, and you have to get the insurance that they say. You have to be very strict with and follow their guidelines.
Yeah,
It'll
well,
cost you more money.
no, Melissa's absolutely right. She says you have to be very strict in what you do, okay? And what happens is, and we'll talk about it in more detail in a couple of weeks when we talk about collective bargaining agreements. But Melissa's absolutely right. Once you have a collective bargaining agreement in place, you have to follow that. And if it says you have to do so many things in a row before you can terminate somebody, you absolutely have to follow that. Collective bargaining, we actually talked about a collective bargaining agreement as an exception to the at-will doctrine a long time ago when we were talking about at-will doctrine. And it is, because if you've got a collective bargaining agreement, it will frequently limit when and how an individual can be fired. So certainly puts in very strict rules. What it does is gets rid of a lot of the flexibility for employers. Okay? Any other benefits or disadvantages to unions?
Well, sometimes the people in charge of the labor side of the union can have too much power and keep things for themselves that they get from employers.
I've seen it a number of times. You have labor unions you have people in labor, and when we talk about labor, what's the other side to labor? You got labor and you got
You have the firm.
the management.
Yeah.
Okay, you have labor and you have management. Now, your labor representatives will frequently they're there to represent who? The labor representatives, union representatives, are there to represent who? Tom?
The union.
The union, and particularly who in the union?
The workers.
The worker. Okay. Sometimes, however, that labor representative, by being the one appointed to management, can actually, for lack of a better term, forgive the expression, be in bed with management, all right? And can say, hey, help me out on this deal, and basically, this guy who's a pain in your butt, I'm not going to go bat for him, okay? And I've seen that. Because anytime in private practice, when people came to me and they were members of a union, I say, go to your union rep. And frequently they said, we have, and they haven't done anything. And there are cases that I eventually took where the union rep should have done something. And why they didn't is beyond me. There are other cases where I saw a guy that should be fired never lose his job and have it 3 or 4 years later, even if he didn't work for a year for whatever reason. And so it can work both ways. But yeah, that's the labor rep can be beholden to the management more than the workers. Any other reasons or benefits? Okay. The other thing, just as personal, that I've seen come out of labor unions is I think we have a lot of pension agreements that have put companies kind of in a trap, where somebody who retires is, and it's particularly true in governmental sector. Not to say it's right or wrong, all right? Don't get me wrong. But where some member of a particular union is entitled to a pension for the remainder of their life, even if they're able to retire at 35, 40 years old. And that draws a real drain upon resources. And in fact, we've seen it here in the city of Springfield with regard to fire workers and policemen. Not to say, please don't get me wrong, I'm not saying that they're not entitled to that pension. In fact, they bargained for it, they got it. But certainly in terms of just overall finances, and maybe goes back to Tom's point as what money do we have, what don't we have, because of union representation and union agreements with regard to people who are entitled to a pension, city may have had a hiring freeze at one point where they couldn't hire additional people because they had to find ways to fund the pension to pay for people who were no longer employed. Okay? So those are all issues, good, bad. You get the idea that there's positives and there's negatives. Why are, and then we'll get into the actual legislation, but why do you think labor unions, and they are, just take the word for it, but numbers are dwindling, okay? Why are there less people in labor unions today than there were? And in fact, probably peaked in the middle 50s. Just by way of statistic, I don't care that you actually remember these. You're not going to see these in an exam. But from 33 to 47, union membership increased to where there was 3 million members. 1933, let me give you the figure. 1933, there were 3 million members. Okay. 1947, just 14 years later, there are 15 million members. Okay. Peaks in about 1955, when practically 40% of the civilian labor force worked in manufacturing. Since the 60s, membership has gone down. Why?
There's not really a need for it anymore.
Okay, and why not, Tom? Tom says there's not a need for it. Why not?
Because we have all this other legislation in place that protects what they're trying to do.
Okay, absolutely. You don't need it as much because you have other legislation in place. Give me an example.
Fair Standards Act.
Okay, Fair Labor Standards Act for wages.
Yeah.
All right, so we talk about wages. The other reason you said labor unions were good was, or what provided benefit?
Higher pay, we have minimum wage.
Have minimum wage, part of the Fair Labor Standards Act that we talked about. What else did you tell me earlier, Tom?
I'm trying to remember.
Okay. Better working conditions.
Yeah, working conditions. We have OSHA.
We have OSHA, Occupational Safety and Health Act, an act that we looked at earlier this year. All right, Melissa, why else?
We also don't have as much manufacturing.
We don't have as much manufacturing. We've become more and more of a service, okay? Not to say that there aren't unions in the service industry, okay? You can have unions over anything, all right? But certainly less manufacturing, so maybe from that standpoint. Any other reasons? Jackie, did you start?
Well, kind of in that same vein. Plus, like historically, at the times that it would have peaked, we would have had that heavy industrial manufacturing, like booming economies. Where now it's a little bit more competitive than that, more education based, and definitely more of a service economy.
Right. And when it becomes, as Jackie says, more competitive based, when it becomes more competitive and more people are worried about job security, they may be less likely to think about striking. And if they're less likely to think about striking, they may be less likely to be part of the union. Okay? And it may be a situation where job comes first, any job comes first because of the other laws that we have over worrying about whether it's a union or not a union. So all of those may come into play. Just by way of background, you had a group of craft unions, and we'll talk about a craft union. And by the way, really two types of major unions, okay? There's what we call, let's go ahead and talk about those now. There's what we call industrial unions. And then there are what we call craft unions. Okay? So you have industrial unions and you have what are called craft unions. C-R-A-F-T. Okay? What's the difference between the two? Based upon that terminology alone, what would you say is the difference between the two? I'm sorry, Dave?
Manufacturers.
Okay, yeah, the industrial union might be a particular group of manufacturers, okay? A group in an industry. So when you talk about an industrial union, it's all of the employees in a particular company or a particular industry, regardless of the occupation. So, for instance, you might have a union of auto workers, okay? People involved in the auto manufacturing process, regardless of what their capacity is within the automobile, okay? Now, compare and contrast that to a craft union. What would be an example of a craft union?
Firefighters.
Okay, I'm sorry, what?
Firefighters.
Yeah, a particular, well, firefighters are still going to be within that occupation, okay? I mean, that's a good point, but that's probably still an industrial, and don't get the terms confused there when we say industrial is thinking manufacturing, because that's easy to do. But no, Corey, a good point. It's, firefighters are a particular occupation, okay? An industrial or occupation. Any others? Another example, or an example of what might be a craft union.
Would it be like a plumber or a carpenter?
More so like that, yes. Because what you have is a particular, or your electrical, okay? You can have your electrical workers associated with the auto industry, associated with the contracting industry, associated with various type of industries, but they're a unique craft, okay? And it could be the same with your plumbers, your electricians, your plumbers, okay? And that's kind of the distinction. Now, you get the idea between the industrial and the craft, and I don't want to belabor those. So back in, just by way of history, 1886. Back in 1886, there was a group of craft unions that formed the American Federation of Labor, or the AFL. Okay. And growth of the unions was kind of slow from 1886 to 1935. In 1935, there was a group of industrial organizations called the CIO. Okay. And these groups merged in 1955 and became what? What were they called? The AFLCIO. I mean, that's just what they became, okay? Because most people have heard that term AFLCIO, okay? And so, as a result, they had pretty strong numbers in the, Amanda.
Was the CIO a craft union also?
It was an industrial. It was a group of industrial organizations, okay? And you can have, that's the overall group. I mean, you'll generally see that if you'll look at any political sign by a Democrat running for office, you'll frequently see a stamp that says supported or endorsed or whatever by the AFL-CIO, okay? Because that'll be a big supporter of the union, okay?
What
Yeah.
year did you say they joined together?
1955. And the CIO basically formed in 35, and it grew pretty quickly, grew pretty rapidly. Did a pretty good job of organizing. Okay. You also, what other conditions are going on in 1935? I mean, you have this AFL group that's formed in 1886. They don't grow all that fast. You have a group that grows pretty fast in the 1930s, which is the CIO. What happens?
The Depression.
Yeah, you got the Depression going on, okay? So a lot more emphasis on, hey, pure survival, we've got to start speaking out, okay? We've got to join. We've got to be, put that strength in numbers. And that's why in 1933, we talk about those statistics, and again, I don't care that, don't get bogged down in the statistics, but that's why in 1933, you have about 3 million members, and it shoots up to 14 million people who are members of the union in 1947. Okay, so it really grows with the formation. Jackie.
Okay, so if you you had more women in factory positions, were they allowed to be in unions?
Yeah, I think,
in the 40s?
were they actually, yeah, I think they were allowed. I think you could have women in unions at that point. Yeah. Okay. All right. With regard to the relationship, let's talk about as we get into these laws. Basically, when we talk about unions, and why do we talk about it in employment laws? Basically, a union, as far as labor relations, is in the context of a written agreement, okay, that has to be interpreted and administered. And that's why we get into labor laws, okay? You have that interpretation of a written agreement. And we'll talk next week about these collective bargaining agreements and kind of how they're formed. But when we come to the laws, as far as some of the laws governing unions, you started out with an Arbitration Act, and I'll just run through some of these pretty quickly. You had an Arbitration Act of 1888. Arbitration Act of 1888. And that act encouraged voluntary settlement of labor disputes in the railroad industry through arbitration. So if you had a dispute in the railroad industry, you had a law that said, hey, we want you to try to settle this if you can through arbitration. Okay? That was in 1888. In 1926, you had the Railway Labor Act. And that's where you really saw most of the laws that the early laws affected the railroad industry. Okay? But the Railway Labor Act of 1926. And it gave railroad workers the right to organize and to bargain collectively with management. Okay. So the federal or the Railway Labor Act really gave a lot of strength to unions because it allowed people within the railway industry to organize and bargain together or collectively, that's how you get the phrase collective bargaining, with management. Now, this act really gave strength to the unions because it prohibited what we call yellow dog contracts. It prohibited what was referred to as yellow dog contracts. And you know, any idea what that was? Basically, that was an agreement in which an employer and an employee agreed that as a condition of an employment, or as a condition of employment, they would not become a member of a union. So we'll pick on Kyle again. I would go to Kyle and I would say, Kyle, you can work for me, but you're not going to be a member of the union. Okay, and if Kyle says, sure, I'll agree to that, we would have what is called a yellow dog contract, and those were prohibited. Good. Now today, there are basically three main labor acts that you have to worry about when it comes to labor law and unions, all right? The first one is what we call the National Labor Relations Act. It's the National Labor Relations Act. It's also called the Wagner Act. And that was passed in 1935. Okay. And we'll come back. Let me list these and then I'll come back to them. The second one was the Labor Management Relations Act. The Labor Management Relations Act. That was in 1947. Referred to as frequently as the TaftHartley Act. The TaftHartley Act. And then the last one was the Labor Management Reporting and Disclosure Act of 1959. Okay. The Labor Management Reporting and Disclosure Act of 1959. It was also known as the Landrum-Griffin Act. 1959. Okay. Now, the main focus of the Wagner Act, or the National Labor Relations Act, was to encourage the growth of unions and to keep management from interfering with this growth. You will hear and you may see from time to time, and that's how we'll refer to it, as Section 7. Just the number 7, not a Roman numeral 7. Okay, Section 7. And that's the basis of the National Labor Relations Act, or the Wagner Act. And Section 7 basically declared that employees had the right to self-organize or to join or assist labor organizations, or to engage in concerted activity So Section 7 declares that employees have the right to self-organize or to join or assist labor organizations or to engage in concerted activity for the purpose of collective bargaining or mutual aid or protection. Yeah. Now, this board is basic, or this act and this law was enforced by the NLRB, which is the National Labor Relations Board. Which consists of 5 members. And the purpose of that board is to make sure that Section 7 rights are not interfered with, and also to set up elections. And we'll talk about how this whole election process works a little bit. Okay. So that was really the basis of the Labor Management Relations Act, and we'll talk about, or the National Labor Relations Act. Okay. Then along came the Labor Management Relations Act in 1947. By the way, what was the purpose of the National Labor Relations Act? Yeah, how did it work? If that was its purpose, how did it do? How?
Well,
Huh?
it did well.
Yeah, it did well. It's because, again, you went from what? 3 million to 15 million. And 15 million was when? Again, I told you didn't have to remember these, and here I am asking you questions about it. But yeah, 1947, which, by the way, is when we had another law come along, right? Okay? And that's the Labor Management Relations Act. And it amended and supplemented the Wagner Act. Basically, I think the idea was, we're going to make sure labor unions are protected, but we don't want the pendulum going too far, okay? So it guaranteed certain employee bargaining rights. And we'll talk about those in detail in a little bit. And it forbade or prohibited unfair labor practices by employers that was established in the Wagner Act. So it carried out that. But then it went so far as to say, wait a second, we got all these laws that say an employer can't interfere. Well, we don't have anything saying a union can't interfere. So we're going to rein in the union a little bit, and we're going to have the TaftHartley Act, okay? And it reins in the union and prohibits certain acts. And again, we'll talk about those. And then in 1959, you have the Labor Management Reporting and Disclosure Act. And that act gives union members the right to nominate candidates for office, to vote in union elections, to attend union meetings, and to examine union records. Okay, so it gives a little more influence, if you will, to union employees. Okay. Now, most of what we're really going to cover is what we call Section 7 and Section 8 rights, all right? And we talk about Section 7. It's important to keep in mind that in order to be protected under Section 7, the rights have to be concerted in order to get that protection, all right? Conduct must be concerted. And what's that word concerted mean?
Everyone
Yeah.
working together.
Yeah, basically everyone together, okay? Now, employees acting individually on their own may not be protected unless they are authorized by or acting on behalf of other employees. Okay? Employees acting individually may not be protected unless they're authorized by or acting on behalf of other employees. If they're acting individually to enforce a bargaining agreement, they are in fact acting for concerted activity. So if they have a particular right that is provided for under the bargaining agreement, and they're enforcing that, even though it's for themselves, it is deemed to be a concerted activity. Okay? But if they're just acting for themselves on something that's not specified in the bargaining agreement, then it may not be. They may not be protected. And I say may not be because we've got a National Labor Relations Board right now that's finding a lot of things may be concerted activity that may not have been a few years or in the recent past. Here's basically the bottom line. An employee's conduct is protected as long as there is an honest and reasonable belief that their behavior will help the enforcement of a collective bargaining right. Okay? So if an individual comes along and says, I'm not going to do this particular job, and if they have an honest and reasonable belief that they don't have to under the bargaining agreement, and the action is directed to the enforcement of a bargaining right, collective bargaining right, then in fact, they're going to be protected. It will be concerted activity. So when you look at this union activity of a particular individual, you have to say, hey, are they fighting for the entire union or are they just fighting for themselves? That's really the key. Okay? Now, it still has to be done in a lawful manner. Okay? It can't be violent. It still has to be done in a lawful manner. Section 8 gave the rights. Section 8A specified unfair labor practices by the employer. Okay? Unfair labor practices by the employer. And here, and let me just list them for you, and then we'll kind of give an example. One of the unfair labor practices prohibited by the Section 8A of the National Labor Relations Act was that an employer could not interfere with, restrain, or coerce employees in the exercise of rights granted to them by Section 7. Now, what were Section 7 rights? Or let me give you 8A again. You couldn't interfere with, you couldn't restrain, you couldn't coerce employees in the exercise of rights granted by Section 7. And what were Section 7 rights? And I know you're writing that down, but what was the whole idea of Section 7?
The employees would be protected, but even if they're, as long as their conduct was going to be good for the collective bargaining.
Which we call what, Melissa?
Unions.
Yeah, what do we call that? If it's good for the group, it's called what kind of activity?
Concerted.
Concerted. Yeah, there you go. Okay? It's concerted activity. Section 7 basically says, hey, you've got the right to engage, to join together. You got the right to come together, to promote yourselves, to self-organize, okay? Engage in concerted activity, you got that right. And Section 8A says, we're not going to allow employers to interfere with that right given in Section 7. Okay, so you need to understand Section 7, you need to understand Section 8A. Section 8A also said it was an unfair labor practice, and these are unfair labor practices. Okay? Said that it was an unfair labor practice to dominate, interfere with, or contribute financial support to a labor organization. Now, why in the world? Okay, let me back up. We've talked about the first unfair labor practice is just a general one. You can't interfere or restrain with any of the Section 7 rights. A second unfair labor practice prohibited by Section 8A of the National Labor Relations Act, and these are all unfair labor practices by the employer, was that you couldn't dominate, interfere with, or contribute financial support to a labor organization. Now, put on your thinking hats. Why does an employer possibly want to contribute financial support to a labor organization?
First with the money has the power.
Okay? But why do they want to?
Bargaining reasons?
Yeah, I mean, if they're giving money to the union, it gives them a little bit more control over, I mean, pretty much every aspect.
Okay.
of the first rate.
If they're given a lot of money, gives them control. Keep in mind also this, that you just don't have one particular union, all right? Frequently, and we talk about these elections in maybe next week, but you frequently have multiple organizations wanting to be the representative union, okay? And you see that a lot in teachers' unions. That's where it's in the news a lot, that we probably see. Teacher organizations, where you have Missouri Teacher Student Organization or the National Teachers Educational Association, or different educational unions. Well, those unions may actually be fighting amongst themselves to be the representative union of a particular group. So, as an employer, goes back to what Jackie and Tom says, if I give my money to Union A and to support them, I may be able to influence that election, and I'd much rather deal with Union A than Union B. Okay, so I'm going to give my money to Union A. But that's why it might be unlawful for an employer to actually contribute financial support to a labor organization. All right. Third, unfair labor practice. Employers are prohibited from discriminating in the hiring or terms of conditions of employment in order to encourage or discourage union membership. Okay? You can't discriminate in terms of employment. You can't hire, you can't terminate, okay? Can't offer better conditions in order to keep somebody from joining a union. Fourth, it was an unfair labor practice, and is an unfair labor practice, to discharge or discriminate against an employee for filing charges or testifying in proceedings. Okay? So if somebody says, hey, there's been a violation of an unfair labor right here, and we were trying to get a union, and somebody has interfered with that, and I'm going to tell you about it. Well, if that employee was immediately fired or could prove that they were discriminated against in some way, then the employer would have been engaging in an unfair labor practice. Okay? Basically, excuse me, we talked a lot about discrimination. We also talked about retaliation. This would be the retaliation for somebody bringing forth a charge or testifying and then being discriminated. Okay? And then finally, for our purposes, it is an unfair labor practice to refuse to bargain with the representative of the employees. Okay? So if you've got a union that's recognized, then it's an unfair practice for the employer to say, sorry, they may be the union, but we're not going to deal with it. We'll talk about bargaining in good faith, okay, later on. But that's an unfair labor practice, okay? How do you tell? How do you tell? Do you have to have the smoking gun where the employer says, yep, we violated those things? No. Proof of actual intent is not needed, okay? You don't have to have proof of actual intent. It is simply conduct that in the board's opinion, what board? NLRB, the National Labor Relations Board, okay? It is conduct that in the board's opinion has the tendency to restrain or coerce employees in the exercise of their rights, okay? So if the National Labor Relations Board thinks that it has the tendency to restrain or coerce employees, a natural tendency to restrain or coerce employees in the exercise of their rights, then it's a violation. Anti-union remarks may in and of themselves be a violation. The test is under the totality of the circumstances, okay? So looking at all of the circumstances. So here's the statement. Kyle comes to me and says, hey, Groves, I'm going to start a union. And I go to Kyle, if you believe unions are going to help you get any more money, get the hell out of my plant. Okay? Violation or not? Probably a violation. That one is pretty clear. Okay? Now, let's make it a little, if I promise benefits. Kyle, you think you're going to get a lot more money by joining a union. Come over to my house tonight. I bet I'm going to have a nice basket for you. There might be a money tree there with $600 bills just for you, okay? Violation? Yeah, I mean, that's an easy violation, okay? Kyle, I'll pick on Kyle all night long. This is fun. Kyle, I saw that you were passing out union organization leaflets, okay? And I saw that as people were coming into the break room, you'd give them one and put it in their lunch sack. I don't want you doing that anymore. Violation? That's a violation, okay? If Kyle, as he's leaving, decides, I really want this union to come into play, so I'm going to get this blimp that you sometimes see at sporting events, dropping things out, and I'm going to put a blimp all over the parking lot, or have a blimp go over the parking lot and drop all kinds of leaflets onto the parking lot. Violation or not a violation? And as an employer, can I do anything about it?
In terms of his rights, is it a violation?
Terms of his rights to hire a blimp to drop all this leaf, or a plane. Let's say he just drops a plane. Propaganda. We did that and we do that in certain wars or conflicts. There you go. Yeah, I can actually curtail that. Okay, and I can say no, you can't do that, Kyle, and I'll prevail in that particular situation. But I can't stop him from taking that same amount of material if he does it in a way that isn't littering. Okay, he can probably put it on his car, unless it gets to the point that people, what do you do when you see that on the car? What you shouldn't do, but what do? You lift it under your windshield wiper, and you should, by the way, put it in your car. But some of you, I know, have picked it off and just thrown it, right? I can tell.
Or you just leave it there.
Or, yeah, okay. And turn on your windshield wipers and see what happens. Well,
No, just leave it there and drive. Leave
Okay.
it go away.
okay, all right. Soliciting, as long as it's in non-working times or non-working areas, okay? That's why I say the break room. But if he gets out of the break room and he wants to, come into the factory while everybody's working on the assembly line and start passing it out. Here, take one of these. I could stop him from doing that. That would not be a violation. Okay? Now, discrimination. We talk about discrimination as a violation. Okay? Adverse job action and intent to encourage or discourage unions. Okay, that would be an example of violation. Okay, let me ask you this. In part based on a true story, results are, we didn't get into the labor union. I work all day long. I come home and I post on my Facebook a note that says, I'm so sick of that blankety blank place. Say Kyle does it, okay? And by the way, Kyle's not smart enough to block me from his Facebook page, right? And I know you are, okay? But if I want, and I look at my employee's Facebook page and I see, gosh, there's Kyle saying, I am so sick of this blankety blank place. Violation or not? And it says no, okay? Let's add a sentence. Kyle says on his Facebook page, I am so sick of this blankety blank page or blankety blank place, and I want everybody else to help me fix it. And puts that on his Facebook page. Violation or not?
Then it at least appears that you're doing it for the collective.
Then it appears that you're doing it for the collective group. And the NLRB, Jackie, would say, you're right. And would say, I can't fire Kyle for doing that. Now, we did, in fact, we had a situation with, it's not confidential, but I won't give all the details of it. But we had an employee who worked at a place, basically said, I'm so sick of this blankety blank place on her Facebook page. We found out about it and we fired her. Now, unbeknownst to us, and I don't really know if it happened or not, but she had a third party, not an employee of ours, truly an independent contractor of ours, that would come over from time to time, and she said that he was sexually harassing her. And we fired her. We didn't know that he was sexually harassing her, if he was. And she turns around and files a discrimination claim against us, okay? It didn't go to the NLRB. I mean, it didn't get to the NLRB portion. But she files this claim, and we ended up saying we're not going to pay a dime, and they eventually dismissed us. They may, if they had wanted to, have an NLRB claim. And here's the key to remember about that. Concerted activity doesn't apply just to unions, employers. Okay? This particular, when I talk about this one that says blankety blank place, that one was not a union. There are no unions at all involved. But the NLRB says it applies, this concerted activity applies whether you have a union in place or do not have a union in place. Okay? So keep that in mind. Couple of opinions real quick, and these both came down this year, really in the last couple of months. Costco has a policy. September 7th, the NLRB issued this decision regarding Costco. What's Costco do, by the way? Anybody know? Yeah, right. They're Sam's. Here's what their policy stated. Any communications transmitted, stored, or displayed electronically must comply with policies outlined in the Costco employee agreement. Employees should be aware that statements posted electronically, such as to online message boards or discussion groups, okay, that damage the company, defame any individual, damage any person's reputation, or violate the policies outlined in the Costco employment agreement may be subject to discipline up to and including termination of employment. Violation or not? You think that's a good policy to have? Yeah, I mean, you hear that policy, you think it's a good policy to have. NLRB says that the employees would reasonably construe the rule as prohibiting violation or Section 7 activity. And while it doesn't specifically reference unions, by its term, the broad prohibition against making statements that damage the company those employees would reasonably conclude that the rule requires them to refrain from engaging in protected communication and therefore probably not going to be allowed. And it's a violation of NLRB. Okay, that was the Costco decision. That came down September 7th. Okay. Then September 28th, the NLRB issued another policy. And in this one, here was the company had a courtesy rule. Okay, it was Carl Canals Motors. So we're not talking any great big company. Okay, and they have a courtesy rule that says courtesy is the responsibility of every employee. Everyone is expected to be courteous, polite, friendly to customers, vendors, suppliers, as well as to their fellow employees. No one should be disrespectful or use profanity or any other language which injures the image or reputation of the dealership. Violation of the NLRB or not? Or a violation of Section 7 or not? Melissa?
The other one was, I would think that one would be too. It's the
Yeah.
same words, just a different.
Basically the same word. It's a courtesy rule, okay? But they say you can't, it's really not so much the sentence that says you can't be nice, it's the sentence that says no one should be disrespectful or use profanity or any other language which injures the image or reputation of the dealership. And the NLRB said, hey, the first sentences there are probably okay, but the second section probably says, prescribes certain provisions and certainly may not be allowed. Okay?
The context of that one is kind of interesting because you can imagine the person who wrote it thought you're just not supposed to use language that our customers would be comfortable with.
Correct.
But
And
if you take just that part that damages the reputation, then it's like, oh, you can't badmouth our firm.
right. Yeah. Okay. So the key there is and where it applies to you all particularly, I mean, from an employee standpoint, not that I encourage you to do it, but you probably can get by with a little more posting on your Facebook. Again, I wouldn't encourage you to do it. But where I really think it applies to you is for potential managers and people in the field, don't be quick to pull the trigger because you see somebody writing something about the company on Facebook. Because if they write it in such a way as to encourage other people to get involved, it can be a violation of Section 7, whether you have a union or not. And you may go, we don't have a union, we don't have to worry about the National Labor Relations Act. Wrong. Okay? So if it can apply to you. Any questions regarding unfair labor practices by the employer? Next week we'll look at the unfair labor practices prohibited by the unions. Okay?